The Supreme Court of Ohio ruled that a 1953 deed transferring land in Harrison County did not retain the rights to drill for oil and gas by stating the owner reserved the right to mine coal or other minerals of any vein. In a 6-1 decision, the Supreme Court found the seller of the land, C.C. Fay, reserved the rights to mine for coal and other solid minerals when he sold the surface rights. The decision affirmed the 7th District Court of Appeals decision that found the current landowners, Faith Ranch and Farms Fund, rather than the heirs of C.C. and Agnes Fay, owned the oil and natural gas rights to the property. Writing for the court majority, Justice Megan E. Shanahan noted the 7th District ruled the language of the mineral rights reservation to be ambiguous and turned to other evidence to determine that the Fays did not intend to reserve oil and gas rights. However, the Supreme Court determined the clause, taken as a whole, unambiguously indicated the Fays were preserving only their rights to coal and other solid minerals because of the words they chose to add to the deed. The absence of words commonly associated with extracting oil and gas indicates that oil and gas were not included in the reservation, Justice Shanahan wrote.
If the grantor intended to reserve the oil and gas when it said minerals, it would have used the apt words to do so. If I own 500 acres in Harrison County, Ohio, and I'm going to convey you the land, and there is a well down the road that is going to make me millions of dollars because I own the oil and gas, I'm not going to only reserve the minerals. I'm going to make sure that you know that I'm reserving the oil and gas.
In a dissenting opinion, Justice Jennifer Bruner wrote that the Ohio Constitution explicitly refers to both oil and gas alongside the phrase other minerals in the context of mining. No other words commonly associated with the extraction of oil and gas are needed to understand that a deed reserving the right to mine coal and other minerals would include oil and gas, she concluded.
There's nothing inconsistent with the use of the word vein from an ordinary perspective to also include oil and gas. In fact, the Ohio Constitution actually uses the word mine with regard to the creation of laws to regulate the oil and gas.
But the opinion concluded that the deed's reference to other minerals of any vein is intended to include items of the same nature as coal, that is, a solid rock in veins, rather than a liquid or gas extracted from a pool or reservoir. You can follow other cases before the court by visiting our website at supremecourt.ohio.gov and signing up for case activity notifications.